Just so you know, this show is about scary stuff. So don't say I didn't warn you guys. And remember, don't be scared.
Episode 94. Irreparably Corrupt. War Baby here with another episode of Murderous Minors. In past episodes, we've talked about the Supreme Court's influence on juvenile justice reform, and there's been a new development. On April 22, 2021, Associate Justice Brett Kavanaugh's opinion in Jones v. Mississippi was released, reflecting the High Court's 6-3 decision that a judge does not have to specifically find that a juvenile murderer is permanently incorrigible or irreparably corrupt and unable to be rehabilitated in order to sentence them to life without parole. The decision does not change any of their previous decisions, but it does not advance the trajectory of the Juvenile Justice Reform Initiative either, with the dissent written by Justice Sonia Sotomayor beginning, quote, "Today, the court guts Miller v. Alabama and Montgomery v. Louisiana." On this episode of Murderous Minors, we look at the case of Bertis Jones, who escaped a dysfunctional home only to have his new life quickly end in violent murder. Please be advised that there are mentions of domestic violence, child abuse, and self-harm in addition to violent murder. Jones v. Mississippi was the culmination of appeals that began over 15 years ago, stemming from the murder conviction of then 15-year-old Bertis Jones in Lee County, Mississippi. Many of the details of Jones' troubled childhood are included in Justice Sotomayor's dissent, as well as in the court records from his trial and the appeals that followed. Jones' parents had been in a turbulent and violent relationship, with it reported that his father abused alcohol as well as his wife, having punched out his mother's teeth and broken her nose twice before they separated when he was 2 years old. He and his mother would later testify that he was prescribed 2 antidepressants, medication for ADHD, and antipsychotic medications around 13 to 14 years old, and that he ceased taking them when he moved to Mississippi. He was actually moving from his home in Jupiter, Florida, where he lived with his mom and brother, to escape his stepfather, an equally vicious man who called the young boys, quote, "little motherfuckers" instead of using their names. According to Jones and his family, the next few years were rife with tension, abuse, and constant moving. He would later describe the situation saying, quote, "Me and my little brother, man, we were terrorized half the time just living there." The brothers described being struck with a belt and choked and being routinely disciplined with a paddle labeled the Punisher. The violence came to a head one night when Bertis Jones missed his curfew. His stepfather pulled off his belt, grabbed the teen by his throat, and threatened to beat him. However, Jones struck out first, badly splitting the man's ear. At the age of 14, he was charged with domestic violence and sentenced to anger management. His stepfather told his mother that either Jones moved out or all 3 of them had to go. His father's parents drove to Florida and picked him up, bringing him to their home in Shannon, Mississippi. The move afforded Jones the opportunity to spend time with cousins and other members of his dad's side of the family, and he felt like he was finally living in a normal home. The teen was excited and optimistic, eager to get started in high school after years of transferring schools and having to repeat the 7th grade because no one could find his previous records. and his girlfriend Michelle had joined him from Florida at the beginning of August. She was living as a runaway. On August 9th, 2004, Bertis Jones discovered that the runaway Michelle was in his house, watching TV with his grandson, and he ordered her to leave. Jones would describe how he and his grandfather got into an altercation while the teen was in the kitchen making a sandwich and holding a steak knife. Jones testified that he'd talked back to his grandpa. They got into a pushing match, and Jones said his grandfather swung at him, causing him to reflexively throw the steak knife directly at the man. He said that he was backed into a corner and had nowhere to go. According to his testimony, Bertis Jones looked down at the knife wound and continued after the teen. The tip of the steak knife had gotten bent as it struck its target, requiring Jones to grab a fillet knife and stab his grandfather repeatedly, rendering the man lifeless. He would later say in court, quote, "I was stabbing him because I was afraid. I didn't know anything else to do because he was so huge. He's not really a big-looking man until he gets in your face with his hands up and swinging at you, and then he turns into a giant, and you just feel like there's no way out. No way to get away from him." The injured man stumbled out of his house, collapsed in the carport, and died. Jones tried to give his grandfather CPR, but stopped abruptly and in an attempt to, quote, "get him out of the yard," dragged him into the utility room at the back of the carport. He attempted to rinse blood from his body with the garden hose and covered other blood on the ground with an oil pan and a mat. While outside and covered in blood, a neighbor saw the teen holding a knife and repeating the word "kill" and called police. Another neighbor arrived and engaged him in a brief and confusing conversation. The teen tried to tell the neighbor that the blood was fake and this was all a joke. His grandfather wasn't home, he said, although the neighbor pointed out that his car was parked in the carport. The men saw Jones and his runaway girlfriend by the bushes, then head out on foot, ultimately running through some woods in search of a ride to Tupelo, Mississippi, and the Walmart where his grandmother was shopping. 3 cousins picked up the hitchhiking teens before stopping at a gas station and calling police. Around 11 p.m., Nettleton, Mississippi police responded and the pair gave them fake names, although authorities were aware of their true identities. Jones had a pocket knife on his person, but explained when asked that it wasn't the murder weapon, which he told police he'd already gotten rid of. Detectives at the murder scene quickly found the body of 68-year-old Bertis Jones in the utility room and saw blood and evidence that some had been cleaned and covered up. Inside the home, blood spatter was noted on the kitchen walls. The discarded clothing was located in the trash, and the 2 knives used in the killing were discovered in the sink. A total of 8 stab wounds were identified, with the cause of death determined to have been stab wounds to the chest. Brett Jones, who had turned 15 just 3 weeks before, was arrested for the murder of his grandfather on August 9, 2004, with his girlfriend being arrested for accessory to murder. He testified on his own behalf and was the only witness the defense called at the 3-day trial in May 2005. Jones' attorneys tried to convince the jury that his grandfather's killing was self-defense and that he'd had no other option but to stab him 8 times. However, his emotionless answers under cross-examination seemed not to sit well with the jury. There were 3 possible decisions the jury could reach: murder, manslaughter, or acquittal. The prosecutor had reminded them in his summation that, quote, "just because you get mad at your grandfather, that's not self-defense." And the jury agreed. After 4 hours of deliberation, 15-year-old Brett Jones was found guilty of murder and automatically sentenced to life in prison with no chance of parole on May 20th, 2005. In 2006, the appeals court denied his request to reverse the sentence, but Jones got another chance once the U.S. Supreme Court ruling in Miller v. Alabama was handed down in 2012. Mississippi did not wait until they were made to begin resentencing their juvenile offenders and began the following year. His life without parole sentence was vacated in the summer of 2013, and his Miller resentencing hearing took place on May 7, 2015, where the same judge who sentenced him to life without parole in his 2005 murder trial sentenced him to life without parole again 10 years later. Jones had testified to hearing voices and about the 3 different medications he was prescribed to treat his depression and ADHD, plus the antipsychotic he began taking in January 2004, only to have quit cold turkey before he left Florida. He described hearing voices as a teen and self-harming, explaining how he used razors, knives, and box cutters to cut himself. The issue with this testimony is that it should have maybe taken place during his original murder trial. Not only that, but the defense did not provide any documentation from doctors or pharmacies or call anyone to testify to Jones' previous medical diagnoses. His attorneys argued that he had only had 1 disciplinary infraction during his decade of incarceration, and had been taking every step offered in regards to education and rehabilitation, even though he had no reason to do so, considering he was sentenced to die in prison. Jones continued to appeal, with his appeals lawyers contending that, although Mississippi committed to their Miller resentencings early, judges continue to routinely sentence and resentence minors to life without parole, and that even life with parole was basically sentencing the juvenile to die in prison. In 2018, the Mississippi Supreme Court heard arguments in the case but dismissed it. In response, the Mississippi Attorney General's office said in a statement that, quote, "No one wants to consider whether a juvenile homicide offender should serve a lengthy prison term or be sentenced to life without parole, but states must consider it, since states are responsible to their own citizens for protecting them, for deterring crime, for assuaging the victims, and for punishing the guilty." This episode is brought to you by EveryPlate. I love anything affordable and healthy that helps me get dinner on the table every night, which is why I put my trust in EveryPlate, because I know I'll get delicious dinners at a delightful price. With recipes that come together in around half an hour, you'll be eating in less time than it usually takes to get out of the store. The pre-portioned ingredients and step-by-step recipe cards leave me with just a bit more time to get things done on those busy weekday nights. In less time than it takes to watch an episode of my favorite show, we can be eating our favorite banh mi bowls with time to spare and extra cash in my wallet. If you need a break from the expensive habit of delivery meals, look no further and get started with EveryPlate for just $1.99 per meal, plus an additional 20% off another 2 weeks by going to EveryPlate.com and entering code WARBABY199. That's EveryPlate.com, code WARBABY199 for $1.99 meals and 20% off your next 2 boxes. Given the fact that these decisions were not unanimous, with 2 appeals court judges and 4 state Supreme Court judges feeling that either the sentencing judge didn't prove that he was irreparably corrupt or that he should be allowed the chance at parole, Jones filed a petition for a review of his case by the U.S. Supreme Court on March 29, 2019. Almost 1 year later, on March 9, 2020, the High Court agreed to hear arguments in the case during their next term, and did so on November 20, 2020, seeking to lay to rest the issue of, quote, whether the Eighth Amendment requires the sentencing authority to make a finding that a juvenile is permanently incorrigible before imposing a sentence of life without parole. David M. Shapiro argued effectively for Jones, the petitioner, and argued is exactly what he had to do when questioned by Chief Justice Roberts.
Is Brett Jones, who committed a crime just weeks after turning 15, permanently incorrigible?
Mr. Shapiro, I'm having just a little trouble figuring out what exactly it is that you're looking for. We know it can't be a formal finding, as I think you indicated, because of Miller and Montgomery's statements. And obviously you want more than just a hearing at which you'd have an opportunity to raise the arguments. But what is it in the middle there? Is it just a statement on the record at some point? during a hearing? Is it, I don't know, some kind of informal finding? What exactly do you need?
On the most fundamental level, Your Honor, what we need is a sentencing judge who understands that permanent incorrigibility is the dispositive rule and determines whether the defendant fits within that rule. And there are any number of ways that it could be done. One is through words, not magic words, but words, but that convey in substance the idea that the defendant is permanently incorrigible, going to commit more crimes, going to recidivate, etc. And one other is that usually you can presume an implicit finding based on the presumption that the judge knows and implies the law, and therefore that a sentence of life without parole implicitly is a determination of permanent incorrigibility, just not here, because this is within the context of a state system that does not recognize the permanent incorrigibility rule to begin with.
Well, at the hearing that took place here, the irreparable corruption, I guess, was the label they used. That was certainly argued by the counsel. You know, he said you have to distinguish between a juvenile offender whose crime reflects unfortunate yet transient immaturity and the rare offender whose crime reflects irreparable corruption. The judge certainly referred to Miller, said he considered each and every factor that is identifiable in Miller, and concluded that the petitioner was not entitled to the benefit of the leniency provided in Miller. Is the problem really just that the judge didn't quote enough passages from Miller? He certainly cited it.
No, Your Honor, that's not the problem. The fundamental problem is that the judge does not appear to have understood that permanent incorrigibility is the decisive rule that he needed to apply. And in fact, in remanding the case, the Mississippi Supreme Court said that the sentence is unlawful if and only if the judge does not consider youth-related factors. And that was an affirmative misstatement of the law. And then the judge said that he was weighing aggravators and mitigators rather than making an assessment of permanent incorrigibility. This is not about a formal declaration. It is about a judge correctly applying the settled rule that this court has laid down.
And with Justice Sotomayor,
well, then you're getting back to you want magic words, because I don't see how this is any different than a regular sentencing where a judge says, I've considered the 3553 factors. We don't question whether they did it or didn't do it. We take them at their word.
Before closing with,
as the Chief Justice noted, we are not asking for much. All that we are asking for is for the rule of Miller and Montgomery, which is a rule stated in Miller, reiterated in Montgomery 7 times as an integral part of its holding, that only permanently incorrigible juveniles can be sentenced to life without parole. And all we're saying is that means that there needs to be a determination. It can be an implicit one based on the usual presumption that the judge knows and applies the law correctly, a presumption that is overcome here, or it can be something more explicit. That is for the states to decide. My friend from Mississippi said that a weakness of our position is that we haven't laid out all of the details. But that's the point. The details are for the states. That is up to them in their discretion. But what there must absolutely be is a determination, implicit or explicit, that the defendant is incapable of rehabilitation before he or she is sentenced to life without parole. All things considered, what we are saying is that there is a rule. This court has laid down that rule in Miller and Montgomery. It is part of the edifice of stare decisis and the stability interest that it protects. And this court does not lay down rules so that they cannot be applied. Mississippi courts need to decide whether Brett Jones is permanently incorrigible.
It took about 6 months, but just 2 days ago, from when I'm recording this, The Supreme Court ultimately decided against Brett Jones in that 6-3 decision, determining that his sentencing judge was not required to prove that he was permanently incorrigible before sentencing him to life without the possibility of parole. Associate Justice Kavanaugh wrote the opinion, dated April 22, 2021, and reading in part, quote, Jones' argument that the sentencer must make a finding of permanent incorrigibility is inconsistent with the court's precedents. In Montgomery v. Louisiana, the court flatly stated that, quote, Miller did not impose a formal fact-finding requirement, and added that, quote, a finding of fact regarding a child's incorrigibility is not required. In light of that explicit language in the court's prior decisions, we must reject Jones' argument. The resentencing in Jones' case complied with those rulings because the sentencer had discretion to impose a sentence less than life without parole in light of Jones' youth. The court's decision today should not be construed as agreement or disagreement with Jones' sentence. We affirm the judgment of the Mississippi Court of Appeals. Importantly, like Miller and Montgomery, our holding today does not preclude the states from imposing additional sentencing limits in cases involving defendants under 18 convicted of murder. Our holding today is far from the last word on whether Jones will receive relief from his sentence. Jones contends that he has maintained a good record in prison and that he is a different person now than he was when he killed his grandfather. He articulates several moral and policy arguments for why he should not be forced to spend the rest of his life in prison. Our decision allows Jones to present these arguments to the state officials authorized to act on them. Those state avenues for sentencing relief remain open to Jones, and they will remain open to him for years to come. Justice Sonia Sotomayor seemed dumbfounded when penning what's being called a, quote, blistering dissent. And just remember that each time she says the court, she's speaking specifically to Kavanaugh's opinion. She said in part, quote, Today, the court distorts Miller and Montgomery beyond recognition, requiring sentencers to make an explicit or implicit determination of permanent incorrigibility before sentencing a juvenile offender to LWOP imposes no costs that justify overturning precedent. Instead of addressing these factors, the court simply rewrites Miller and Montgomery to say what the court now wishes they had said, and then denies that it has done any such thing. Jones and other juvenile offenders like him seek only the possibility of parole, not the certainty of release, but the opportunity at some point in their lives to show a parole board all they have done to rehabilitate themselves and to ask for a second chance. In resentencing Jones to LWOP, the sentencing court failed to apply Miller properly. It never addressed Miller's central inquiry, whether Jones is one of the rare juveniles whose crimes reflect irreparable corruption. Because the sentencing court failed to ask and answer this critical question, Jones' sentence should not stand. Brett Jones will be 32 years old in July of 2021 and remains incarcerated at South Mississippi Correctional Institution in Leakesville, Mississippi, where he's been housed since August 2020. In 2019, that facility was on lockdown for a staggering 7 months over a shortage of prison guards, and was placed back on a lockdown that extended to other prisons in the state on December 30th, 2019, after an inmate there was killed. Mississippi law states that once Brett Jones reaches 60 years old, he can petition for a conditional release. After the first time his sentence was upheld, the judge allowed him to speak, and he said, quote, I've pretty much taken every avenue that I could possibly take in prison to rehabilitate myself. I took anger management in prison. I've taken trades, got my GED, stayed in touch with my family. I'm not the same person I was when I was 15. If you decide to send me back without the possibility of parole, I will still do exactly what I've been doing for 10 years. But all I can do is ask you, please give me just one chance to show the world, man, like I can be somebody. I've done everything I could over the past 10 years to be somebody. I can't change what was already done. I can just try to show I've become a grown man. Minors do have the ability to change their mentality as they get older. All I can do is throw myself at the mercy of the court.